Daily list item number 1. Lordship, I'm entering appearance on behalf of respondent number 5, Lordship.
Yeah, please, Your Lordship.
Who's 5?
5 is the private respondent, Lordship.
Those are the complainants.
Okay.
I'm appearing for 1 to 4.
1 to 4.
Your Lordship, in this matter, we are in the process of filing impleadment application, Your Lordship. In the earlier writ, we were made a party there, and as such, we are required to be heard, Your Lordship, in this matter. I'm the acting chief of the Langren CMship.
Your Lordship.
Your Lordship.
Your Lordship.
Why have you not made them party?
Well, they're not a party, Your Lordship. Here the question is only between the complainant and myself, who has been removed. Because on the basis of their complaint, I was suspended by the District Council. And this is an inquiry case. The acting team is not even a party in the proceedings before the inquiry officer. How can he be a party? This writ petition, Your Lordship.
Lordship, we may be allowed to file an impleadment application, Lordship. If any order passed by this Honorable Court, there's every likelihood we may be prejudiced, Your Lordship.
There's no question. They're not a party to the inquiry proceedings, Your Lordship. How can they come and implead? They should have impleaded themselves before the inquiry officer.
Will satisfy, Your Lordship.
What is your grievance?
Your Lordship, I'll come to that. I have a very limited grievances. Here, Your Lordship is well aware about the facts. There was a complaint launched by me, by the respondent number 5, alleging various allegations. Now the District Council has suspended me. Against this suspension order, I have approached before this Honourable Court. Now this Honourable Court, by judgment dated 3/5/2023, have passed a direction that they have dismissed the writ petition and allowed me to take part in the inquiry proceedings. Now what has happened before the inquiry proceedings, Your Lordship, is that we were under the impression that inquiry proceedings ought to be conducted in a fair manner. Your Lordship is well aware, in a criminal proceedings, what are the procedure followed? An FIR is filed, investigation is conducted, charge sheeted, sent to the court, then prosecution is appointed for the state, and the defense has their own counsel to defend. But in this inquiry, Your Lordship, what has happened is that charges were framed, they have appointed an inquiry officer. Now, there's no presenting officer on behalf of the District Council to present the case to prosecute us. But, surprisingly, is the complainant themselves. They are prosecuting the case with the assistance of the District Council. They have vested interest, Your Lordship. Your Lordship is well aware. They have vested interest in the matter. Now they are prosecuting us without any documents in their favor. Now they file applications before the inquiry officer to call for the records. And the inquiry officer will take cognizance of the records. Let's settle law, Your Lordship. The inquiry officer cannot judge the inquiry by herself. I'll take Your Lordship to some very relevant paragraphs. 20.
Before my friend goes to the relevant paragraph, I just want to draw Your Lordship's attention to their prayer. What is their prayer before this court? Well, you'll see page 35 of the writ petition. Before we go into the merits, my lord, in the premises aforesaid, it is prayed that Your Lordship may be pleased to call for the records, issue a rule calling upon the respondents to show cause as to why a writ in the nature of mandamus be not issued directing the respondents to withdraw, recall, or forbear from giving effect to the impugned order dated 21/8/2003. So what has been impugned in this writ petition, my lord, is the order dated 21/8/2023, which has also been impugned in the earlier writ petition. Lord, this order has
the earlier writ petition which was disposed of.
and appeal is pending.
Appeal is pending.
Yes. Now, my lord, they have not annexed a copy of the additional affidavit which they have filed before this court in the first writ petition. But in fact, in your judgment, my lord, at page 222, your lordship will see.
Yes.
Para 5, my lord, on the last portion. The petitioner has then filed an additional affidavit on 12/9/2023 to bring on record the actual order of suspension dated 18/8/2023, wherein it was stated that on receipt of the complaint against him, the petitioner was accordingly placed under suspension pending inquiry, and during the pendency of such inquiry, an acting CM is required to be appointed. Hence, the appointment of respondent number 5 as acting CM. Now, my lord, this is important. 6. Further, the petitioner has also produced copy of the communication dated 21/8/2023. This is what has been impeached in this writ petition, my lord, whereby the respondent number 4 has informed Shri So-and-so, Magistrate First Class KGDC, Maukorbat, who was appointed the inquiry officer, to look into the allegations complained against the petitioner. So, my God, even by the principles of constructive res judicata, this court cannot entertain this writ petition to challenge an order which is already attained finality.
Which has already figured in
Yes.
the in the
Not
earlier
only
order.
figured, my lord, in the additional affidavit which they have filed, they have clearly stated that I'll just
Mr. Dingro,
Yes.
all said and done. See, as Mr. Numbri has pointed out, by virtue of this order,
yes.
the inquiry was allowed to continue.
Yes.
So, the inquiry remains alive,
Yes, the inquiry is
which-
continuing.
to which the parties can, raise objection or raise any issue
Yes.
in course of such inquiry, which was done so.
Yes.
If I understand
The
the
lordship is
matter
absolutely
correctly,
right.
which was done so, in as much as in course of inquiry some
Orders have been
anomalies or some irregularities have crept in as much as there is an allegation of certain
True.
parties not connected to the inquiry being
But have those orders been challenged here before your lordship? No.
that
Your
remote-
lordship,
The challenge before this
we are
says an
challenging the
order which-
inquiry proceedings, the manner in which, the procedure in which it has been conducted. I'm not against the inquiry, but it has to be conducted. A free and fair inquiry has to be conducted, not in this manner, your lordship.
But look
I'm
at their
only
prayer.
against that, your lordship.
Look at their prayer. What have they come before this court?
Your lordship, the earlier writ petition was filed only against the suspension, because the order contained two aspects. One is suspension and one is an inquiry.
And if they have any grievances as against the inquiry officer, they come before the executive committee. Let them come. Let them file a complaint.
Inquiry, executive committee themselves has appointed inquiry.
Exactly. We have appointed the appointing authority. We have
Lordship,
appointed the
under
inquiry officer.
226, your
If they
lordship, we
have
only
any
come here
grievances,
for a free and fair. Article 21 has been violated, your lordship. Only against that. Let them file their affidavit.
I think the parties have to file it. All the respondents have entered appearance.
except for them, they want to file an application.
Okay, you file, then we'll look into it.
Yes.
In the meantime, the other respondent can file their counter affidavit. In fact, the moment you file your counter and also your application, we'll dispose of this matter at the
Your
earliest.
lordship. But in the meanwhile, lordship, those proceedings should not proceed, or else
no,
I'll
it
be
cannot-
prejudiced, lordship.
How-
Or else my petition will become infructuous, lordship.
How can the
We'll have to
proceedings,
look into
how
that
can this
aspect
court,
also, your lordship.
in this writ petition, stay the proceedings of the inquiry?
If that because I'm coming against the proceedings, your lordship, if that continues, then what is the point for me coming to this court?
No, my lord. For that,
But Mr. You look at the scenario. What would happen?
no, but look at the prayer, my lord. They have not. The
Let
challenge
them
is
file
not the
it. In
inquiry
meanwhile, your
proceedings.
lordship will educate on the matter.
The challenge in this writ petition is against the appointment of the inquiry officer, which is already attained finality. This
My
court has
alternate
already
prayer is,
upheld.
Lordship, only to keep in abeyance till the matter is decided by this court.
Have you, is there any specific verments to that?
Yes, Lordship.
Where's your prayer?
In your prayer?
Miscase, Lordship.
See, Mr. Nobri, it need not be reminded that
Keep in abeyance,
for a
Lordship,
matter to be
page 12 of my miscase.
for a matter to be properly adjudicated, there must be specific pleadings and prayer.
Yes. Miscase, Lordship, page 12.
If you have not made a prayer in your main case, how can you make a prayer in your
Why,
Your Lordship, these are unnecessary technicalities raised, Your Lordship.
They're not technicalities, my lord. These are very vital.
Your Lordship, can you see
If
page
your lordship
36?
passes any order,
Page 36, Your Lordship,
Will be barred
page
by it.
36 of my writ petition. I've made a prayer in the main writ petition and also a miscase, Your Lordship. Till then, only the next date, the proceedings will be stayed. Thereafter, if they file the affidavit, the matter can continue.
and my lord, the fact is that they are taking part in the inquiry now for how many months? 8 months. And suddenly they come. It's fixed
Your
for
Lordship,
evidence.
Evidence has not yet started. That is why, Your Lordship. Where anything before
now
the
after
trial
8 months
starts,
they
Your Lordship, we are all open to come before this court.
Anyway, if the respondent so deem it necessary, have you filed any objection to the dismiss application?
No, Lordship.
Not yet, my lord.
You do it.
Yes, before passing any order, we'll file an
I'll
objection.
hear first we'll hear on this application first day. Do it.
In the meanwhile, Your Lordship, it has to be kept in
that
abeyance.
What is the stage? When is the next hearing?
10th of July, Your Lordship.
10th of July. Today is Thursday.
Today is 27th.
We can hear it next week.
No, we'll take it up tomorrow.
Not tomorrow, my lord. Let it be difficult. Next week, Tuesday.
Your Lordship, I'm only praying for
Tuesday or Wednesday?
for on the 10th of July. Only that date
Otherwise, yes.
may be
Tuesday
kept
or
pending.
Wednesday? Tuesday or
Only
Wednesday we
10th
can
of
hear.
July, Your Lordship, may be kept pending, because we need to file rejoinders also if they file their affidavit.
If it may be fixed on the 9th, my lord.
Ninth.
Lordship.
9, Your Lordship, next day is the trial.
We'll take it up on the 8th then.
8.
Lordship.
Mr. Nobri, we'll take it up on the 8th. In the meantime, the parties are requested to file their objection
Point here, my lord.
with advance
Your Lordship
copy.
will not delay.
With advance
Our
copy
only
to the
prayer,
petitioner.
Your Lordship, is that we'll keep praying that on the 10th, only on the 10th, be kept in abeyance.
Let us see how.
Once the matter
Let us
is,
see how the matter transpired
Lordship.
on 8th. If the court so deem it necessary, and a proper order would be passed on the 8th, whether to stay the proceeding or to deal with the matter altogether. As far as your application for stay is concerned.
But the moot point here, my lord, if the writ petition itself is not maintainable, where's the question of interim?
That will be looked into, yes, because now
When,
first
when
we
the
have,
main
we,
writ
have,
petition is barred,
we have to address the immediate problem.
absolutely, Your Lordship.
Mr. T. Dingdo, Leonard Senior Counsel, appearing for the respondents
1 to 4.
1 to 4, has submitted that the said respondent may be allowed to file an objection to the application for stay filed by the petitioner in miscase number, in this miscase, pass order miscase, in this miscase. Similarly, Ms. Sanjishla, counsel appearing for the respondent number 5, would also submit that an objection may be allowed to be filed as far as the prayer made in this petition is concerned. Prayer allowed. Considering the prayer made by the petitioner, the respondents are directed to file the said objection within the next date fix with advance copy to the petitioner who may file a rejoinder to the same if so desired, and a matter to be finally heard on the next date fix. This is the matter on 8th. Any complaint case there? Mr. T.T. Dengro, London Senior Counsel, appearing for the respondents number 1 to 4 respectively, has sought for some time to file the counter affidavit. Is the affidavit ready?
Not yet, my lord. We'll file it within.
Similarly, Ms. Angela, London Counsel for the respondent 5, has also submitted that the counter affidavit may be allowed to be filed within the next date fix. Ms. Leonard Counsel has also made a prayer that an application may be allowed to be filed seeking impleadment as far as you are the acting SIM or chief?
I think same.
Acting SIM is concerned.
I'm not required to seek permission also, Your Lordship.
Hello. We'll list this matter also on 8th. Main case.
Yeah.
We'll also list this matter on 8th.
On 8th, yes. Yes.
Counter affidavit may be filed. This is matter on 8th.
Item number 4.
And Your Lordship, if they file, I may be allowed to file my rejoinder.
I've already indicated.
Your Lordship. I didn't hear, Your Lordship. Sorry.
They will file with an advance copy to you.
Your Lordship.
In the meantime, you can file your rejoinder so that the matter will not be prolonged. On the 8th itself, the matter will be taken up for hearing.
Your Lordship.
Lordship, there was a request from the counsel for the respondent that he's not keeping well. So I also had to come back, Your Lordship, and they informed me that they wanted to ask for time. That's why I did not come to the court. Be that as it may, let it be a last chance, Your Lordship.
But the counsel is here,
Lordship, this is the respondent is a state.
or stay.
Dr. N. Muzika is special counsel. It's been specially appointed by the state.
Submission has been made.
Maybe for 2 weeks, Your Lordship, for the last chance. Maybe 2 weeks. Every week it has been coming.
Submission has been made on behalf of the
Respondent.
state respondent, seeking accommodation on the ground that the learned senior counsel appearing for the state is indisposed or on grounds of personal difficulties. The petitioner has no objection to the said prayer made. Accordingly, matter is adjourned. This system after 2 weeks.
It can come after 3 weeks, Lordship. No urgency. There's no urgency as well, Lordship.
Why not? See,
They are pressing for the
delay.
Lordship.
They are pressing for the matter.
They've been
My prayer,
pressing
Lordship,
all
after 3
along.
weeks.
Yes, but be sure. See,
Lordship,
though I would
we
not,
understand.
I would not put it in writing as far as last chance is concerned. But
Lordship, I'll convey them.
please convey to the
Lordship,
senior counsel that matter has been heard.
Lordship.
3 weeks.
Oh, much obliged. Much
Very
obliged.
obliged.
Second call, item number 1.